Please, sir.
I got a copy also.
Give it.
Give them a copy.
Where is the list?
Only 3, my lords. List is
Departmental
there in the
inquiry,
departmental inquiry only.
Criminal trial.
Criminal trial ಆಗ್ಲಿಲ್ಲ, HPC ಅಷ್ಟೇ. ಅದು ಆವಾಗ exoneration ಆಗಿರ್ಲಿಲ್ಲ. After framing the charge, HPC has been, I have been exonerated.
Before charge ಅಲ್ಲಿ ಇದೆಯಾ?
ಇತ್ತು.
ಈಗ ಏನಾಗಿದೆ?
ಇಲ್ಲ, ಈಗ only charge was framed because at that time exoneration was not there.
Right, now charge is framed and trial is on.
No charge, trial is on.
Charge frame ಆಗಿಲ್ವಾ ಇನ್ನು?
Only charge frame ಆಗಿದೆ.
Stay is there.
Entry ಮಾಡಿದೆ.
Please.
FDT ಅಷ್ಟೇ ಇದೆ. Only charge was framed, my lords, at that time.
One moment. ಅದೇ ಆಶು follow ಮಾಡಿ.
Please, Ashu follow. Now, my lord.
Oh, entry order spread for up. Yes, sir.
Your lordship may kindly see. I'm aware that charge at the time of framing charge, the departmental inquiry exoneration was not there. Not only departmental inquiry has been conducted, but even Lokayukta accepted the departmental inquiry findings conducted by the department. So now I have virtually 2 exonerations. One is by the department. Second is by the Lokayukta. Now government has also accepted it. In normal case, my lords, department conducts inquiry and government accepts it. In my case, not only department conducted the inquiry, whole inquiry report was given to Lokayukta. And Upalokayukta, after having seen that, concurred with the findings, and again they sent to government because government has referred them.
ಎಷ್ಟು amount? Failed trap.
15,000 ರೂಪಾಯಿ.
Failed trap. Successful.
Successful trap.
Who took the money?
She only one accused.
Only one accused.
Only one accused.
So all tests were done?
Done. But everyone, not even one person has supported.
If a trap is laid against you, answer it. If a trap is laid against a government servant and trap only he is caught red-handed, like how the petitioner is caught red-handed. So money, there is acceptance.
Obliged.
No problem. Without demand, acceptance, section 20 kicks in, that presumption, that is demand is there, acceptance is there. In this case, how a departmental inquiry can be conducted and said that there was no demand and acceptance? How is,
No, your lordship may kindly.
how is it, you tell me? If cases where somebody else has taken in somebody else's name, ಯಾರ್ದೋ ಹೆಸರಲ್ಲಿ ತಗೊಂಡು ಇವ್ರ ಹೆಸರಲ್ಲಿ ತಗೊಂತಾ ಇದೀವಿ ಅಂತಂದ್ರೆ there is some meaning. You are caught red-handed.
Your lordship may kindly see, that is only an allegation.
Were you not caught red-handed?
No, that is an allegation.
Allegation Allah. Your caught red-handed is not an allegation.
No.
It is a step beyond allegation.
No. Your lordship may kindly see the report, inquiry report as well as witnesses.
This is exactly the point. Where does criminal proceedings be interdicted in a departmental inquiry where demand and acceptance is again gone into when it has to be under the Prevention of Corruption Act?
No, your lordship may kindly see. No, that's what they have read. Your lordship may kindly see.
Trial ಆಗಿದ್ರೆ ಇಲ್ಲಿ same witnesses ಮಾಡಿದ್ರೆ ಆವಾಗ we can do something. We can't interdict the trial.
Your lordship may oblige it. Now, what has happened in Ashu's case, my lords? Ashu's case is same, identity department were different. CVC's finding was verbatim accepted in the criminal proceedings, and entities were different. Here in Chandrasekhar's case, your lordship may kindly see, entire case, I have made a clear-cut distinction between both. Your lordship may kindly see, in that case, in Manjunath's case and Chandrasekhar's case are concerned, they have completely forgotten the fact that different.
Who has forgotten?
The
Supreme Court.
Supreme Court.
Oh.
Because they have not mentioned. Your lordship
So
may
you mean to say Supreme Court has forgotten?
No, nobody has brought to their notice. That is what per incurem is all about. What is substantial issue, my lords? I have written. I mean, your lordship may kindly see.
I'll have to repeat. If I accept your statement, I'll have to repeat. Northeast is a beautiful place.
No, not. Your lordship may kindly see. What is your lordship may kindly see? There is a different. That is a specific finding. I may be permitted to read the judgment of Chandrasekhar.
I have read.
Different. What they have gone on 2 aspects.
See, Ashu followed Radheshyam Kejriwal.
Obliged.
Ajay Kumar Tyagi.
Obliged.
PS Rajya.
Obliged.
Chandrasekhar does not refer to Ashu, but follows Radhesham Kejriwal, Ajay Kumar Tyagi, PS Rajya.
Obliged,
Yes.
obliged.
All of them were three-judge bench decisions.
Obliged.
Ashu was also three-judge. bench.
Obliged.
So not considering a
No, no,
subsequent three-judge
no,
bench.
your lordship may kindly see what is what is stated in that case. What is the opinion of Honorable Apex Court? Apex Court categorically says entities were different. In Radhesham case, entities are same. In this case, they say entities are different.
One more thing is, in all those cases, trial had progressed.
Obliged,
When did it go to the Supreme Court? When
obliged.
did it go? As a criminal appeal, not under 482.
No,
No,
under
no.
482. Your lordship may kindly see. It is discharge. T. Manjunath was a revision petition.
D. Manjunath alla, Ashu na ಹೇಳ್ತಿರೋದು. Ashu,
Ashu.
Radhesham,
Ha, ha, ha.
all of them went after the orders of either acquittal or conviction.
No, no. Ashu's case, there was no conviction or acquittal. Ashu's case was at the stage of commencement of the trial like mine. Your lordship may kindly see the factual matrix. They have
Difficult.
explained in detail. Then even specifically, it has been specifically stated in
See,
facts
in
itself.
Chandrasekhar, the Apex Court delineates, these are the witnesses in the departmental inquiry. These are the witnesses in the criminal trial. They are totally different. That's what Supreme
Yes,
Court has said.
no, I have gone through, my lords, as your lordship has gone through. There are only on two grounds they did not agree. The ground number one was entities are different. And in Radhesham Agarwal, the Supreme Court has said, they have only, the court has said, and when entities are same and in hierarchy, the specific word used is in hierarchy, when a superior officer overrules the order of a subordinate, in such cases, they said Radhesham's Agarwal's case is concerned, that has been taken into consideration. But they say in this case, Jalamandal is a different entity, ACB is a different entity, therefore it cannot be accepted. So lordship may kindly.
If you had not been caught red-handed, I would have examined everything. But you're caught red-handed. Quantum is not the issue. But a public servant being caught
No, quantum
red-handed,
is-
receiving money, will not receive any refuge in this court.
Your lordship may kindly say, in the even now, we are on the simple point. Whether what is material, whether what is in the charge sheet is the material or on oath, this is the case
Oh, I
where
fail to
examination.
understand. Disproportionate assets are there, because
How?
records
That
are
I agree.
there,
That-
income tax kotirtare, you can
Obliged.
departmental inquiry. 7A trap when you are caught, how is a departmental inquiry conducted on demand and acceptance when you're caught red-handed and exonerated?
That's why I'm making a submission. It is only an allegation, my lords. What is evidence or what is material? After evidence.
ಯಾಕೆ ತಗೊಂಡ್ರಿ?
ತಗೊಳ್ಳೇ ಇಲ್ಲ.
ಮತ್ತೆ ನೀವು ತಾನೇ ತಗೊಂಡಿದ್ದು red-handed, caught red-handed
Their
ಏನರ್ಥ?
allegation.
ಹ?
That is their allegation.
Oh, my lord.
What has come out, your lordship may kindly see it. That's what even the,
Where is Peter?
are you,
Panchnama?
My lord, FSL report is positive, my lord.
You-
Even
your
voice-
lordship may
voice
kindly
records are
see.
sent to FSL. My lord, opinion is there. They have not even produced the entire charge sheet. My lord, and my lord, even the phenolphthalein test was conducted. That is also, my lord,
Yes,
turned
phenol-
positive. My lord, this
I
is
am
not
not
matter of
agree-
trial, my
Where
lord.
is the
Let them
question of
file
allegation?
no,
discharge.
no, your lordship may kindly see.
This is not the question of allegation with presumption in section 20.
No, your lordship may kindly see what has transferred in the evidence which is recorded on oath. On oath, when we have to, chance when 482
It's a
can be.
matter of trial.
Please.
I'm not saying you're guilty, but you should be tried.
No, your lordship may kindly see trial, I would have faced happily, my lords. But because even now, your lordship may because all these materials are not placed before the court earlier. Your lordship may kindly see under section 5 of the Karnataka Departmental Inquiries Act, all the proceedings before the inquiry officer is a judicial proceeding. In my proceeding also, oath has been administered. So it is a judicial proceeding. When in a judicial proceedings,
A
my lords,
departmental inquiry is a quasi judicial proceeding, not a judicial proceeding. Anything else?
your lordship may kindly
It's a
see.
quasi judicial proceeding, it's not a judicial proceeding.
Your lordship may, that is in the departmental inquiries where oath is not administered, it is quasi judicial. When, my lords, oath is administered, What is judicial proceeding, my lords? Any proceeding, the definition is given. What is the meaning of judicial proceeding? The meaning of judicial proceeding is a proceeding wherein oath is administered is a judicial proceeding. There's the definition given to judicial proceeding. Even I have written in my synopsis that also, my lords.
ಕೊಡಿ
Normally, my lord, government.
But normally I would have not argued. my lords.
ಕೊಡಿ. We'll see, this requires an answer, we'll answer.
Section 80, and one more thing is there on section 80 also.
ಇದೆ, ಇದೆ.
My lords, there is a presumption about anything conducted in departmental inquiry. That is, if the certified copy of a judicial proceeding is produced in any other proceeding, my lords, prima facie, any certified copy or a content of that copy has to be accepted at its face value. Your lordship may kindly see now the proceedings which I have faced is also departmental proceedings.
ಇಲ್ಲಿದೆ ಬಿಡಿ, ಅದೇನು?
Section 80. Adu very
ಕೊಡಿ.
little. Your lordship may kindly see the proceedings which I have faced is departmental proceedings, wherein proceedings is conducted as a judicial proceeding. In criminal proceeding is also same thing. When both are same, my lords, in both, because perjury, I have got, your lordship may kindly see, I can, if and your lordship can ask some question if I am unable to answer, because
Yeah, no problem.
no,
You answer, you argue,
then
sir.
it's fine, my lords. I will
Why are you
accept
telling I
it.
should ask
But
questions?
your lordship, I will be happy if the court is asking me any questions. See, my humble submission, I'm aware, my lords. Your lordships are trying to say that once the apex court says something, that too on referring to a particular judgment, this court has to follow it. But my humble submission before this honorable court, 3 important points are not taken into consideration
By the apex court.
by the apex court.
All right. ಹೇಳಿ.
Because number 1 is judicial proceeding, no distinct, because in Manjunath's case, the lordships have specifically said in other proceeding and as well as in Chandrasekhar's case, in criminal proceedings, there is a possibility of witness giving some other set of evidences because in criminal proceedings, they are exposed to perjury. Therefore, there is a possibility of these witnesses coming out with a different set of facts. Therefore, their lordships have said that is also one of the circumstances which has to be taken into consideration. But in this case, my lords, what inquiry I have faced is a judicial proceeding. Therefore, yes, oath is administered. Therefore, I have produced those copies also wherein oath is administered. And second, it is conducted under Karnataka Departmental Inquiries Act specifically. And third, any proceedings, my lords, before Karnataka Lokayukta under section 11 of the act is a judicial proceeding. They are open to 193 IPC also. And as well in Karnataka Departmental Proceedings Act also, any witness gives a contradictory evidence, they are exposed to section 193 perjury.
Procedure is under 14A of KCS CCA.
Only procedure, my lords. But proceedings conducted are under 11. Any proceedings, the word used is any proceedings conducted before Upalokayukta or Lokayukta is a judicial proceeding. In this case, my lords, Upalokayukta entrusts the investigation to them and it is continuation of the same proceeding. It is not a different
Upalokayukta
proceeding.
does not hold inquiry. It is DRE 5 idralli 4.
3,
DRE 3, yes.
closure proceedings. And it has been accepted by Upalokayukta. They accept it. And then government also accepts it.
No, we'll
And
answer.
second is,
This requires an answer because there's so many petitions pending. We'll
some
answer.
other day.
ಥರ್ಡ್ ಏನೋ ಹೇಳಿದ್ರಲ್ಲ ಹೇಳಿ. Some other day ಇಲ್ಲ ಅಷ್ಟೇ, ಇವತ್ತು ಇಷ್ಟೊಂದು ಟೈಮ್ ಸ್ಪೆಂಡ್ ಮಾಡಿದ್ಮೇಲೆ ಮುಗೀತು. Third submission.
Your lordship may kindly see. In Chandrasekhar's case, what they say is, the IO had supported the case fully, and their lordships have gone to an extent of saying, on verifying the evidences of PW 123
Where?
in Chandrasekhar's case.
Where? Criminal
In
trial?
departmental inquiry.
Ah.
In departmental inquiry. In departmental inquiry. The court says, though it has not been challenged before us specifically, but it will not detain us from going through their evidence only for the purpose of showing that even the order of exoneration is not on merit because complainant has supported in toto. He has spoken about demand and acceptance in Chandrasekhar. And secondly, their lordships say that even punch witness is concerned, he has stated about entire trial proceedings except the fact that he has not heard the conversation. And then their lordships, they say that even investigating officer has given the evidence. That is, in that case, IO was not examined. But in case of T. Manjunath, only IO was examined and he has supported the entire case in toto. So in both the cases, my lords, their lordships have said, after going through the inquiry report, they could find manifestly the material which is sufficient to find the accused guilty or say that the disciplinary authority could have proved the charges laid against them. They say there are sufficient materials to find that the charge alleged against them are proved. There is a specific finding in Chandrasekhar's case. That's why they say exoneration is not on merit. Even that wording is there. And their lordships have said,
Yes,
because
their exoneration was not on merit, but I'm aware.
so the distinction could be exoneration of merit includes hostile witnesses or not. For that also, my lords, in my synopsis I've written, what is evidence? Evidence is what is the chief and cross-examination read together is an evidence. It is not what the prosecution or disciplinary authority
In the
produces.
criminal trial, that stage is yet to come here. Evidence ಎಲ್ಲ ಆಗಿದೆ.
Departmental
Departmental
inquiry
inquiry
ಆಯ್ತು ಅಲ್ಲ ಅದು ಬೈಂಡಿಂಗ್ ಅಂತ my humble submission
Binding ಅಂತ.
exoneration is binding. If even Chandrasekhar's case, the proposition has not been disputed. Then at the beginning only their lordships have said, your lordship may kindly say,
Noted, I've seen
Single.
that judgment.
but still for my
All
satisfaction.
right, really, yeah.
Despite this court having consistently held that disciplinary proceedings and criminal prosecution, even on identical allegations, are parallel proceedings, the relevancy of the conclusion is one is often contended to be binding on the other. Right is the principle that in a disciplinary proceeding, the proof is of preponderance of probability, while in a criminal proceeding, it has the highest standard of proof beyond reasonable doubt. Often it is argued that acquittal in the criminal proceedings should incur the benefit of accused delinquent employee in a disciplinary proceeding too. In the present case, we have a contrary contention of disciplinary proceedings having exonerated the delinquent employee who seeks absolution from the criminal prosecution. The contention is that when the allegation could not be proved in a disciplinary proceedings, when allegation could not be proved in the disciplinary proceedings, where the requirement is only a preponderance probabilities, surely it cannot be proved beyond reasonable doubt. Your lordship may kindly see further, while distinguishing, their lordships have specifically quoted Rajesham Agarwal, and threadbare discussion is made on Rajesham Agarwal, wherein, my lords, because entire thrust was given on two issues, even marking is there at para 38, where they say the finding in the adjudicatory proceedings in favor of a person facing trial for identical violation will depend upon nature of finding. So I am on that point. It is on nature of finding that has not been disputed. If the exoneration in adjudicatory proceedings is on technical ground, not on merit, prosecution may continue. So question, my lord, says, in that case, in that particular case, their lordship has specifically stated it is not on merit because complainant had supported the case. In my case, absolutely nobody has supported, and even the amount found is 18,000 rupees and not the 15,000 rupees. So that itself shows that entire thing is different. And their lordships have specifically stated that entities are different. So in Radhesham Agarwal, they say that entities are same. Here they are different. And important aspect of judicial proceeding is not taken into consideration.
All right. We'll take it into consideration.
But in the event, my lords, in the event this honorable court feels that Chandrasekhar's case itself is applicable or T. Manjunath's case itself is applicable.
ಮಂಜುನಾಥ್ ಕೇಸ್ ಇದೆ ಕೊಡಿ.
Manjunath.
ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದೀನಿ, ಅದರೊಳಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ. ಮಂಜುನಾಥ್ ಇದೆ.
Supreme Court has remanded the matter, my lord, to the Honorable High Court.
So there's Natarajan or order.
Please.
ಕೊಡಿ. ಅದು exoneration ದೇನಾ?
Please, there are two issues, my lord. Sanction as well as exoneration. But matter is remanded, my lord, and argument is going on in that.
ಎಲ್ಲಿದೆ?
Krishna Kumar. ಇಲ್ಲೇ ನಡೀತಾ ಇದೆ.
ಬೇರೆ ಕೋರ್ಟ್ ನಡೀತಾ ಇದೆ.
This is Krishna Kumar ಅವರು.
All right.
In T. Manjunath, your lordship may kindly see, it was on the point of discharge, wherein there are plethora of cases. At the time of discharge, court
Yeah, of course. Yes.
court cannot look into exoneration in departmental inquiry. I'm not on the point of discharge because there is under 482, there is a specific bar. But I am not on that. I am on the point that continuation will be abuse of process. I squarely fall upon Bhajan Lal. So your lordship may kindly see,
Let me see. We'll consider.
I may be permitted in the event. I mean, not now, I'm in the, to take all these contentions in my trial because it is judicial.
ಈಗಲೇ ತಗೊಳ್ಳಿ. I'll pass that order. You want me to pass a detailed order? I will pass on because this issue requires an answer. Wait, so that other cases it will be. In the event, definitely I will permit you.
Because it is a judicial proceeding, an observation, my lord, that judicial proceeding under section 80, therefore I may be permitted to take that contention in the trial.
No, you want to withdraw this now?
If court has made up my mind,
No, made up mind.
I have to withdraw it.
No,
Because
made up my mind. This requires an answer because all those things that you have submitted now does require an answer. We'll see
Obliged.
judicial proceeding, all that we'll consider. Yes.
But here, but the learned friend argued, my lord, PW 1 to 3 has not supported the prosecution. Here, PW 2 and PW 2, my lord, partly supported the prosecution case, and PW 3, my lord, IO fully supported. the
IO will definitely support. Who else will support prosecution?
And my lord,
If
normal.
IO is turning hostile, then it is over. I would have straight away quashed entire proceedings
And my lord,
everywhere.
PW 3 regarding, my lord, conducting of inoculum test, my lord, trap mass, my lord, regarding that aspect, even PW 2, my lord, supported the case of prosecution.
IO's
No,
case, my lord,
let's raise some legal
Please,
questions.
legal
to answer.
regarding,
and
Free judge bench of Ashu is not considered in the later judgment.
but however, my lord, regarding judicial proceeding, my lord, Radhesham Kejriwal and, my lord,
That
judgment, my lord, it is answered. But it is completely
Department
different.
Inquiry Act.
department inquiry.
And here is a case, my lord, there is specific demand and only one accused. And my lord, by following Neeraj Datta case, my lord, recently, but honorable apex court,
Here at the.
when there is a, alala, Karunanidhi case, my lord, when there is specific
I'm
demand.
really-
And
When I was shocked,
Parliament.
my lords, in Manjunath's case, the lordship, I mean, it is
And-
written specifically that IO's evidence itself is sufficient. Your lordship may kindly see where in Neeraj Datta's case it is
But in this
stated
case-
that IO's evidence is sufficient.
but in this case, A2 was, my lord, acquitted. However, A1, because there is a specific demand from the A1, the honorable apex court will not answer the following Neeraj case when there is
See,
specific demand. Please,
that's the whole issue. We'll see.
please. Because my lord, FSL report
No,
is
no,
received,
no,
everything is
please.
there, my lord, to show that.
Heard the
matter of
learned
trial.
counsel A. Shankar,
Shankar Hegde.
Shankar Hegde, sorry.
Shankar
Shankar
is
Hegde
sufficient.
appearing for the petitioner and Prasanna Shetty representing the respondent Lokayukta reserved.
Much obliged.
Interim order subsisting will continue till the disposal of the petition.
Much obliged.
Eleven.